Hi everyone, welcome to another video by SG Company Services. Today we're going to talk about personal data and the Personal Data Protection Act in Singapore. All information shared are for educational purposes only. Any changes or amendments are subjected to the Personal Data Protection Commission of Singapore. Personal data refers to data about an individual who can be identified from their data or from that data and other information to which the organization has and is likely to have access. The Personal Data Protection Act or PDPA provides a baseline of standard of protection for personal data in Singapore. It complements sector-specific legislative and regulatory frameworks such as Banking Act and Insurance Act. It comprises various requirements governing the collection, use, disclosure, and care of personal data in Singapore. It also provides for the establishment of a national Do Not Call Registry. Individuals may register their Singapore telephone numbers with a DNC registry to opt out of receiving unwanted telemarketing messages from organizations. The PDPA recognizes both the need to protect individuals' personal data and the need of organizations to collect, use, or disclose personal data for legitimate and reasonable purposes. A data protection regime is necessary to safeguard personal data from misuse and to maintain individuals' trust in organizations that manage their data. By regulating the flow of personal data among organizations, the PDPA also aims to strengthen Singapore's position as a trusted hub for businesses. The PDPA covers personal data stored in electronic and non-electronic formats. It generally does not apply to, number 1, any individual acting on a personal or domestic basis. Number 2, any individual acting in his or her capacity as an employee with an organization. Number 3, any public agency in relation to the collection, use or disclosure of personal data. Number 4, business contact information such as an individual's name, position or title, business telephone number, business address, business email, business fax number, and similar information. Organizations are required to comply with the various data protection obligations if they undertake activities relating to the collection, use, or disclosure of personal data. What are these obligations? Number 1, accountability obligation. Undertake measures to ensure that organizations meet their obligations under the PDPA, such as making information about your data protection policies, practices, and complaints process available upon request, and designating a data protection officer or DPO, and making the business contact information available to the public. Number 2, notification obligation. Notify individuals of the purposes for which your organization is intending to collect, use, or disclose their personal data. Number 3, consent obligation. Only collect, use, or disclose personal data for purposes which an individual has given his or her consent to. Allow the individual to withdraw consent with reasonable notice and inform him or her of the likely consequences of withdrawal. Once consent is withdrawn, make sure that you cease to collect, use, or disclose the individual's personal data. Number 4, purpose limitation obligation. Only collect, use, or disclose personal data for the purposes that a reasonable person would consider appropriate under the given circumstances and for which the individual has given consent. An organization may not, as a condition of providing a product or service, require the individual to consent to the collection, use, or disclosure of his or her personal data beyond what is reasonable to provide that product or service. Number 5, accuracy obligation. Make reasonable effort to ensure that the personal data collected is accurate and complete, especially if it is likely to be used to make a decision that affects the individual or be disclosed to another organization. Number 6, protection obligation. Reasonable security arrangements have to be made to protect the personal data in your organization's possession to prevent unauthorized access, collection, use, disclosure, or similar risks. Number 7, retention limitation obligation. Cease retention of personal data or dispose of it in a proper manner when it is no longer needed for any business or legal purpose. Number 8, transfer limitation obligation. Transfer personal data to another country only according to the requirements prescribed under the regulations to ensure that the standard of protection is comparable to the protection under the PDPA, unless exempted by the PDPC. Number 9, access and correction obligation. Upon request, organizations have to provide individuals with access to their personal data as well as information about how the data was used or disclosed within a year before the request. Organizations are also required to correct any error or omission in an individual's personal data as soon as practicable and send the corrected data to other organizations to which the personal data was disclosed, or to selected organizations that the individual has consented to within a year before the correction is made. Number 10. Data breach notification obligation. In the event of a data breach, organizations must take steps to assess if it is notifiable. If the data breach likely results in significant harm to individuals and/or are of significant scale, organizations are required to notify the PDPC and the affected individuals as soon as practicable. Number 11. Data portability obligation. At the request of the individual, organizations are required to transmit the individual's data that is in the organization's possession or under its control to another organization in a commonly used machine-readable format. In recent years, there have been an increasing number of cases of data breach and mishandling by organizations from various fields and of different sizes. To read more of these cases of data breach and attack, visit www.sgcompanyservices.com/data-protection. If an organization is found guilty of any PDPA breach, it may be liable to a maximum fine of 10% of its annual turnover or 1 million Sing dollars, whichever is higher. All organizations, including sole proprietorship, are required to designate at least one person, a data protection officer or DPO, to be responsible for ensuring that the organization complies with the PDPA. Organizations are also required to ensure that at least one DPO's business contact information is made available to the public. The business contact information may be a general telephone or email address of the organization. The DPO may be a person whose scope of work solely relates to data protection or a person in the organization who takes on this role as one of its multiple responsibilities. To be clear, compliance by the organization with the PDPA remains the responsibility of the organization, notwithstanding the appointment of the data protection officer. The PDPA does not prescribe where the data protection officer or DPO should be based. The DPO need not be an employee of the organization, and organizations may outsource this function to a certified third party like ourselves. However, the DPO whose business contact information is provided has to be reachable wherever a member of the public in Singapore attempts to contact him to be compliant with the PDPA requirements. An organization is responsible for all personal data in its possession or under its control. This may relate to not just employees' data, but personal data of other persons such as clients or shareholders. The PDPA requires an organization to designate one or more individuals to be responsible for ensuring compliance with the PDPA. Your company will have to ensure compliance with the PDPA as long as it is collecting, using, and disclosing personal data or has personal data in its possession or control. This includes appointing a DPO. The PDPA does not stipulate a minimum age for DPOs. However, the appointed person should, for example, have the appropriate expertise and knowledge to be able to ensure that the organization complies with the PDPA and develop a process to receive and respond to complaints with respect to the application of the PDPA. There is no deadline to register your DPO. However, we strongly encourage your organization to register your DPO as early as possible so that he or she can be kept abreast of the relevant personal data protection developments in Singapore. As a certified data protection officer, our team is able to provide the necessary support for your organization to fulfill its PDPA obligations in a hassle-free manner. If you have more questions regarding the Act and its implications, drop your questions in the comment section below and we are happy to answer them. Remember to subscribe today if you'd like to see more similar videos. Thank you for watching and I'll see you in the next one.